What does equal athletic opportunity mean after West Virginia versus BPJ? Did the Supreme Court just simplify the rules for transgender student athletes? Or, as is often the case, did they just make things more complicated?
Well, as we all know, nothing clears up a difficult legal and ethical issue than a Supreme Court decision.
I wish that were true.
Oh my gosh. So here we are. We're talking about the Supreme Court decision in West Virginia versus BPJ. They have now weighed in on one of the most contested recent issues in schools, whether states and schools can limit girls' sports teams to students whose biological sex is female. But as we know, Supreme Court decisions don't implement themselves, folks. So here we are, once again, trying to parse things out and help schools figure out what all of this stuff means. So let's not waste any time. Let's get into it. Let's talk about the most recent Supreme Court decision in West Virginia versus BPJ. Are you ready?
I was born ready.
Okay. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, telling the fascinating stories connecting the courtroom to the classroom.
It's for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright.
All right, Jamie, before we get into today's case, do you have a bell ringer for us?
I do. So this one comes out of Ohio, and it is...
Hey, me too.
Yes, that's right. You do come out of Ohio, don't you? So this case comes out of the whole parental rights and social media First Amendment file, once again.
Okay. Stuff we've covered pretty extensively.
Pretty extensively, yes. So a divided panel of the Sixth Circuit just brought back an Ohio law that required kids under 16 to get parental consent before using certain social media platforms and gaming apps.
Oh, interesting. Okay,
Yeah.
so the law requires kiddos to get parental consent before creating these profiles.
Right.
It sounds like that got struck down.
It did. It got struck down.
Interesting. Okay.
And then it went up to the Sixth Circuit. So what happened here was there was a group out there, Net something, I can't remember, and it represented a bunch of social media companies like TikTok and Snapchat, and that group challenged the law, and they said it was vague and overly broad, and it was a violation of the First Amendment. And they've been successful challenging similar kinds of laws in other states, but not so with the Sixth Circuit. They said,
interesting.
No, that's not the case here. So,
okay.
In a 2-to-1 ruling, they said that it was a pretty modest law and it was aimed at mitigating a pretty important problem, children entering these platforms without adult oversight. So, the law stands, and now this is another decision that we can add to the Protecting Kids versus Parents' Rights file.
Right. Yeah, because this is a great alignment of two things we've talked about a bunch, which is, the harms of social media and kind of all that litigation going on right now with that, but then also the tension between parents' rights and students' rights, or children's rights in this case,
right?
Where the Supreme Court, and that was one of our big critiques of Mahmoud, or my big critique of Mahmoud, is it basically says that kiddos' rights are going to be realized through their parents. And this is another one of those examples where maybe this does infringe on children's free speech rights, but because it's parental consents, parents are kind of being positioned as being in charge of, or at least, the ones who are best situated to protect their kiddos' rights and interests. So yeah, that's a really interesting, right? Because like you and I have talked about, we want to make sure that kiddos are protected from the harms of social media, but how do you do that while also respecting their rights? Yeah.
Yeah, totally.
Interesting. Yeah. Very interesting.
So yet another case that complicates, or it's not it's just another case in,
that reveals how messy all this is.
Exactly. All right. So that was the bell ringer. And speaking of bell ringers, you might, I don't know if you can hear it, but there's actually a bell ringing right now. So once again, as I do every summer, I help run a summer camp up in Canada, and I'm up here right now. So there could be some kids playing ambiance that, I'm just not in a studio anymore.
And I'm glad we timed that perfectly.
Yeah, I know. That's actually kind of crazy. So that bell rings pretty much every hour. Anyway, okay. So let's use that transition bell to transition into the BPJ case that we're going to talk about today.
So did we just transition out of the bell ringer with a bell?
We did. I think that might be a first for John.
So is this now also a bell ringer?
No, I don't know. We'll debate that offline. All right, so let's talk about the BPJ decision. So we've also been calling it the transgender student athlete case. This decision came out on the last day of the term, which was like June 30th or something?
June 30th, yep.
Yeah. Actually came out on the same day as the birthright citizenship decision that the Supreme Court weighed in on. So in many circles, the transgender athlete case kind of was glossed over or trumped, as you could say.
As you might say.
By the birthright citizenship case. So on Chalk and Gavel, on the other hand, we're an education law podcast. So as significant as that birthright citizenship case was, I would say that the BPJ decision outshadowed the birthright citizenship case.
I'm also much more qualified to talk about the BPJ case.
Yeah, let's not get into that one. Yes. So listen, we're not going to spend a ton of time talking about the facts in this case because we covered the lower court decision back in episode 57. And we covered the oral arguments in the BPJ case in episode 62 back in, January, something like that, right? Mm-hmm. So if you want a deeper dive into the facts and how things played out before all of this got to the Supreme Court, go ahead and check out episode 57 or 62. Today, though, we're going to dig into the decision. We're going to talk about sort of what this, what happened with this decision, what it means for schools, all of that stuff, right? The first thing I want to say, though, is what's really at stake with this decision? I guess we could ask, who gets to define what fairness means in school sports? Is this just about eligibility? What about belonging, dignity, safety? What about opportunity? It's about balancing fairness and inclusion, federal, state law, OCR guidance and enforcement. It's about balancing all of those things while trying to actually run schools on a day-to-day basis, right? Right. So, there's a lot at stake here. And does the decision in BPJ help us with any of this? Maybe. I mean, at the very least, it removes some ambiguity, I guess. Yeah.
But there's so much at stake here. And in many ways, these decisions, because there's so much at stake, get overly simplified. And, I think highlighting those different tensions and different ways of understanding what's at stake here really could just kind of highlights how complicated these cases are.
Yeah. So, if getting into it, you might remember that there was another case that was working its way through along with the BPJ case. That was Little versus Heacock, which dealt with a transgender college student who wanted to compete on teams that aligned with her gender identity. And the BPJ case was about an eighth grade student, at the time, an eighth grade student, transgender female who wanted to run on the cross country team, right? So the oral arguments for both of those cases were held at the same time, and the decision we're talking about today decides both cases. All right.
Right.
So and the reason they did that is they presented pretty much identical legal issues, and the Supreme Court kind of does that when that stuff happens. So the BPJ case challenged a West Virginia law titled the Save Women's Sports Act, which prohibits biological male students from playing sports on female teams. The Hecox case challenged a similar law out of Idaho. So let's just go ahead and dive right into the opinion. You ready?
Opinions, because there are five of them.
Yes, that's right. It's never really one opinion.
No, a lot of people had a lot of thoughts about this case, as you might expect.
As you would expect. Exactly. So what do we got?
Right. So what's interesting is we've got these five opinions, but this is a 6-3 or a 9-0 decision, depending on which claim we're talking about. So the Supreme Court upheld the West Virginia and Idaho laws basing athletic participation on biological sex assigned at birth. So the states win, and they may exclude transgender female athletes from female sports teams.
Yes, and I do want to point out here that it's important to mention that it really didn't cover anything about transgender males.
Right. And that was something that came up a bunch in the lower court opinion, and the oral argument is like, this is a one-directional law. Yeah. So isn't that by itself sex discrimination? And spoiler alert, that is nowhere in the majority opinion. So we've got these five opinions, and importantly, kind of, Jamie, to that point, like this opinion expressly doesn't decide a bunch of stuff. And one of the things they expressly don't decide is whether or not states may allow transgender student athletes to compete in alignment with their gender identity. So this is just about whether or not states can disallow.
Yeah.
Right. Yeah.
Yeah.
And so, there's a footnote number 1 says, quote, "These cases do not present the distinct question whether schools may allow biological males who identify as female to participate on girls' or women's sports teams." So those cases are still working their way through the system. But as we're going to talk about, some of the arguments in this case apply with equal force to, the permissive approach, just as they do to the exclusionary approach. So they say that it doesn't apply, but reading the tea leaves here doesn't give me a lot of confidence.
No, and I would say while it might not give us a lot of confidence, it is important to take the opportunity right now to read past the headlines. Okay, and this is what we try to do here on Chalk and Gavel. It's what we try to, teach our students to do, and everything is to kind of dig a little deeper, right? And don't fall for the clickbait. This is not a ban on transgender athletes participate. Right. It's a may, not a must. Okay?
Exactly. Right.
And that essentially leaves things a little bit more open for some states, even though they're in the minority now, states that allow transgender athletes to play on teams that align with their identity.
Right.
It doesn't prevent them from keeping those. Now, does it complicate what they're trying to do?
Or does it, give some additional legal cover to those who are trying to challenge those inclusions?
Yes.
Right?
Exactly.
And I think that's a great point, because, there's, according to this opinion, there's 27 states that limit participation to biological sex, and there's 23 that don't.
Right.
And so, if this decision ruffles feathers, then, there's a path, right? Because it's not a you cannot, it's a you may.
You may. Right.
Yeah. No, that's a great point.
Yeah.
So there's five opinions. Mentioned that. We've got a majority opinion authored by Justice Kavanaugh, which really shouldn't surprise us for reasons we'll talk about in a minute. At oral argument, he was very into the this is all about sports angle. Yeah. And so that opinion was written by Kavanaugh, joined by the other 5 conservative justices. So majority opinion gets 6 votes. We also had concurring opinions from Thomas and Gorsuch, who wrote for themselves. So 2 concurring opinions. And then we've got a dissent in part and a concurrence in part, which is why this is a 6-3 and or a 9-0 decision. The 3 liberals, in an opinion by Justice Sotomayor, disagreed about how the court handled the Equal Protection Clause, but would have come to the same conclusion under Title IX, which I think is very, very interesting.
Wow.
And then we also have a lone dissent and concurrence in part from Justice Jackson. So our primary focus is going to be on the majority opinion by Kavanaugh, because that's the binding opinion. But it's interesting to kind of trace the dialogue going on here between the opinions, because they are talking directly to and sometimes past each other, for sure.
Surprise, surprise, surprise.
I know. So the majority opinion, I already alluded to this, but like the fact that Justice Kavanaugh wrote this opinion is his, let's say, positionality comes through very, very strongly in this opinion.
He's a sports guy.
100%. Because honestly, that is my biggest takeaway from this opinion, is that if this were in any other context other than the sports context, I don't know if this decision comes out the same way.
Wow.
If it does, it would be at least a very different opinion.
Huh.
Because Kavanaugh is, as you said, he is a sports guy. He loves sports. He's coached his daughter's youth basketball team.
Right.
I think he coached them to like some like city championships, which is super cool. Like he is.
Didn't he say in that in his confirmation hearing, he's like, I like beer.
He did, right?
Yeah, I still like beer.
Right, and nothing goes together like beer and sports, right?
Yeah.
Right. No, like it is very much like this is.
He's a man's man.
In a way, yeah. Like it's like a I want to sit down and watch a game with Justice Kavanaugh kind of thing, right? That's kind of how he's writing this opinion.
I get it. Yeah.
And there are pieces of this opinion that are basically like pure odes to sports and the value of youth sport participation. So like I've got this passage here, Jamie, that I would love to get your read of. And I want you to give this some Kavanaugh gusto.
I don't know. This is not going to be, this is going to be Cudlett's gusto.
Okay.
You
could still be Coach K, because I think that's what Kavanaugh's kiddos call him.
I'm telling you, no one wants me to coach a team. That's, you don't, no one wants that.
Go sports.
Okay. Okay. So here's the quote, read with some kind of gusto. Women and girls who play sports care deeply. They obsess. They spend extraordinary time and effort to train in the heat and in the cold, to work out early in the morning and late at night, to get a little faster, to become a little stronger, to jump a little higher, to shoot a little better, to watch a little more video, to make the lonely journey back from an ACL tear, to scrap for playing time, to start, to win the game, to win a championship, to hang a banner, to bring home a medal. There's so much here.
No, but okay, I think you kind of get the point, right? Like this is like all about the value of sports, and just the lessons and like the competitive nature of them. Yeah, because this goes on for a while.
Yes. They put a championship trophy or an all-league award on their bedroom shelf, and it stays there forever as a reminder of their love of the game and pride in their achievements. They learn to endure losses with grace, to lift up their teammates and to respect them. I get this. It's
right.
It's a powerful little coach. What do we call it? Encouragement coach.
Yeah. It's a good pep talk for
motivating pep talk. Right.
And I think that is core. Like Kavanaugh's understanding of sports is core to this opinion.
Well, obviously, you read that,
right? Yeah,
like this. Here's your coach, right?
Yeah, he obviously likes sports, but he emphasizes the competitive nature of sports really hardly. Really hardly?
No, let's not use hardly, because I think this does not mean what you think it means.
He emphasizes the competitive nature of sports really hard. Over what you might say are some of the more educational aspects of participating in sports.
Yeah, being a member of a team and working together and, helping each other, all of this.
Right, and developmental, right? Like getting better, not saying who's the best.
Practice.
Right? Yeah. Talking about practice. So in multiple places in the opinion, Kavanaugh talks about sports as this like zero-sum situation.
Winners and losers.
Exactly. So, this idea of like zero sum shows up at least 3 different places in the majority opinion. So like it's in 3 different discussions. And, I think that is maybe not like, I worry about that framing of sports as being highly competitive at zero sum, because that's doing a lot of work in Kavanaugh's reasoning.
And I think you could probably find a lot of examples that don't prioritize the zero sum competitive nature.
Right.
Like there's a lot out there.
Yeah. And that's actually one of the things that the dissent kind of takes the majority to task for. The dissent points out that for BPJ, everyone who tried out for the middle school team made it. Like there were no cuts here. There's still issues around playing time, which is something that Kavanaugh makes a big deal about, and like medals and things like that. Like, if someone gets a bronze medal, that means someone else has to get 4th place.
Right.
But I do think that raises a really interesting argument that I would love to see more developed in, any of these opinions, which is that like maybe middle school sports have a different purpose than other more, advanced athletic participations. Like maybe there's a difference between elementary and middle school sports and the NCAA or the Olympics. Right? Like, I think especially when we connect these to schools, maybe there's an argument for the educational value, and maybe we can subsume some of those like competitive fairness values to those educational concerns.
Right. It'll be very interesting to see along those lines. It'll be very interesting to see, let's say, for example, a state or a school system or whatever, or a state athletic association actually drafts language that defines the purposes of their interscholastic sports,
right. Which I'm sure exist.
I'm sure that it exists, but like what's going to be interesting, we talked about this before, is some of the states that allow transgender athletes to participate, for example, are potentially fighting a more uphill legal battle if their permissions are challenged. But it will be interesting to see if there are states, for example, that really focus their definitions of sports at different levels on those issues that we were just talking about. When those policies do get challenged, how will they be reconciled against the BPJ decision that is so strongly, or hardly, as you put it eloquently before, focused on the competitive nature?
Right.
And so that's going to be fascinating to me, right?
Who gets to decide what sports are for? Like, does Justice Kavanaugh get to decide that they're all about competitive fairness, or do the school districts and athletic associations get to decide that, like, no, these are about inclusion?
We're trying to do a different thing here.
Education. Yeah. Right. So the last thing I'll say about the sports angle, and Kavanaugh and I might see sports a little bit differently, but I love this aside that he has in the majority opinion. So this is like apropos of nothing, comes out of nowhere. It's just an aside in the opinion in parentheses. And he's talking about the safety risks of contact sports. And Kavanaugh, in an aside, directly addresses like the naysayers of women's sports. And he says, quote, "Anyone who thinks that these women's and girls sports are not contact sports has not witnessed a game recently."
What?
Yeah, that's in a Supreme Court opinion.
Seriously?
Yeah.
Well, that I like.
It's so funny because it's like, it's a plug for women's sports in a Supreme Court opinion by Justice Gorsuch. So, go catch a women's sports game with Justice Kavanaugh.
Yeah, no, okay, I'm struggling with this a little bit because like there are a lot of sports that are not contact sports, right?
Right. And that's actually an interesting point because that goes to something we'll talk about in a minute, which is like the fit between the justification and the line that the law is drawing. And if we're worried about like safety, like, safety for competitive sports or like contact sports, that might justify a certain line in football or boxing, but it might not justify the same line in track and field.
High jump.
Yeah. Right. So, I think that's actually a really interesting point. And Kavanaugh and I guess the majority doesn't really distinguish between sports in the same way. So, maybe that's a fit issue.
Listen, I recognize that I am completely out of my element discussing sports, and
that was a very insightful point, though.
Well, thanks. All right, so let's get back to the opinion.
Yeah. So the majority opinion, obviously huge emphasis on sports, and like so many different places in this opinion does it say like, especially for the sports context, or, given the context of sports or athletic participation, like all of it is about like sports. But the opinion starts with a brief history of Title IX and like how it transformed athletic opportunities for women and girls. And then, that pivots into talking about why Title IX was necessary to kind of promote equal athletic opportunity.
Right.
And so it evolves into kind of a discussion of these inherent physical differences between men and women, why sex-separated sports teams are necessary. So again, we've kind of talked about this a bunch, but, safety concerns with contact sports and, competing against people who are potentially bigger, stronger, faster, whatever it might be. Right. And then fairness concerns for the same reason, right? Like we want to make sure that these are, fair because we want to see who's the best.
Right.
And so, those are kind of what the majority opinion kind of celebrates those as celebrates Title IX as kind of addressing those dual concerns.
Okay.
And, it goes on to then to say that, it's not fair to force female athletes to compete against male athletes. And then it says that, 27 states and the NCAA and the Olympic Committee have all adopted bans or have all banned biological males from competing in women's and girls sports. So there again is that comparison between middle school and the Olympics. Like it's already there.
Yeah. Like it's this or nothing. Right.
Or that we should treat middle school athletics like we do the Olympics.
Yeah.
Right.
Yeah.
So, while sports do dominate a lot of the opinion, what isn't as prevalent in the opinion?
I have an idea.
You'd probably be right, because the word transgender really only appears in the majority opinion when the court is responding to arguments or summarizing arguments from BPJ or the dissent.
Because I would think that they would want to stay as far away from that as possible, because I think it opens them up to heightened scrutiny.
Hey, in a lot of ways, actually, that was a good one.
You like that?
Yeah, and so here's the most telling example. So in I guess very telling, but not technically incorrect description, the majority characterizes BPJ. So when describing BPJ and others like her, the court says and describes her as, quote, biological males who identify as female, end quote. So nowhere do they say BPJ, a transgender girl, right? Right. And so it's this language that is very telling, very troubling, because, it seems to talk about BPJ
in ways
a lot
of work. Yeah.
Right. Exactly.
Yeah.
And it previews how the court is thinking because, as you said, they see this as, and they're framing it as purely sex discrimination based on biological sex, not transgender discrimination, because, as you said, that would open up a whole different can of worms.
Yeah. So that's why they're not calling it transgender. They're just defining it this way so that they can potentially avoid wading into those complex waters, right?
Right. Which they do largely.
Yeah.
So getting into the legal claims, BPJ and then also Hecox brought a combination of Title IX and equal protection claims.
Yeah, so 14th Amendment, yeah.
14th Amendment, right.
Yeah.
So starting with the Title IX claim, the question the court says it's answering is whether or not Title IX permits schools to maintain women's and girls' sports for biological females. So again, to your point earlier, this is a may. They do this?
Yes. And the answer is, they can, if they want.
Yeah. So how did the court get there? They talk about the origins of Title IX. It was passed in 1972 to prohibit sex discrimination in federally funded programs. A couple of years later, there's some regulations that say you have to provide equal athletic opportunities for members of both sexes those regulations also authorized separate teams for members of each sex.
Yeah, that was called the Javits
Javits amendments, right? Yeah. And then the regulations implementing the Javits amendments, right?
Yeah.
And so, we've got this regulation that says you can have separate teams for members of both sexes.
Both sexes.
And so the 6-justice majority concludes that, and this is actually a really interesting and what I think is probably the most significant Title IX part of this opinion. They say that the term sex in Title IX cannot plausibly be interpreted to refer to anything other than biological sex. So we've talked about what does sex mean? Could it also mean gender identity? All of those other things that kind of are wrapped up in our understanding of sex. And the court says, nope. They say under Title IX, sex means biological sex. And because Title IX's regulations allow for separate sports teams for the sexes, that means that it follows states can have separate teams based on biological sex. So the states win. The reason I say it might not be as big a deal is because Gorsuch files a concurring opinion. So Justice Gorsuch wrote the majority opinion back for the Bostock case a couple of years ago. Right. Bostock was a Title VII law, which is very similar to Title IX, that prohibits discrimination based on sex in employment.
Yeah.
And in that opinion, which was also joined by Chief Justice Roberts, Gorsuch wrote that because transgender or sexual orientation discrimination is inherently based on an individual's underlying sex, right? You can't tell if someone's transgender or gay unless you know what biological sex they are. That any discrimination based on those characteristics is, at least in part, discrimination on the basis of sex. And that, according to that rationale, violates Title VII. And so here, BPJ is arguing that just like in Bostock, Title IX, same rationale applies. This is, if you discriminate against me because I'm transgender, that is, at least in part, because of my underlying biological sex, which would also violate Title IX. And the majority says, not so fast, because unlike Title VII, Title IX actually has a carve-out for athletics. So, it prohibits sex discrimination, but then it says, unless you want to have separate teams for the sexes, that's okay. So basically, it's not discrimination because there's a carve-out from Title IX. And then Gorsuch, in his concurring opinion, basically says, I don't read the majority's opinion in BPJ as foreclosing the possibility that, just like in Title VII, transgender and gender orientation discrimination could also be impermissible under Title IX for the same reasons, because Title IX allows for or prohibits discrimination on the basis of sex. Discrimination based on transgender status or sexual orientation is inherently, at least in part, on the basis of sex. And for Gorsuch, the distinction here between Bostock and BPJ is that Title IX expressly allows for sex-separated teams. So, Title IX allows for sex separation in a couple situations, athletic teams, bathrooms, living accommodations, locker rooms. And so while I think that the BPJ opinion suggests that all of those kind of distinctions or sex separated facilities and things like that might be upheld by the Supreme Court, the liberals in dissent and Gorsuch make it clear that a law or an act or somebody who discriminates based on transgender status, and there's no way to kind of sidestep that question, that could violate Title IX. And so even though sex under Title IX might mean biological sex, that doesn't foreclose the idea that Title IX, outside of these exceptions, could still prohibit transgender or gender identity discrimination.
So I guess one potential hypothetical that could fall into that category is if a state created a law that basically said, you know what, we're going to open up a third team or something. You can't play on the boys' team, you can't play on the girls' team. Here's another team you can play on.
Or if a state actually said what it was doing and said transgender girls can't be on the boys team or the girls team.
Right.
Because then it's like, oh, well, that's obviously transgender-based discrimination. That's not
kind
sex
of what
discrimination.
I meant.
Yeah.
You can't do it here. You can't. Yeah.
That kind of law might be analyzed differently.
Interesting.
Right?
That's interesting.
Yeah. So that's why I say, like, yes, it's important that they define sex to be biological sex under Title IX, but that doesn't necessarily answer all the questions outside of these contexts.
Right. Exactly.
Because the sports context is everything here.
Yeah.
And so, the other counter argument that BPJ makes here, other than the Bostock argument, is that, the effect of this law is basically to deny her any opportunity to participate because she's never gone through male puberty. So she can't compete on the boys team. And then, if this law is upheld, she can't compete on the girls team.
Mm-hmm.
And you can tell that Kavanaugh is sympathetic to people who want to participate, but for whatever reason can't, because, he really values athletics. He wants people to participate.
Yeah.
He even goes so far at the end of the opinion to say that, no one should be vilified for wanting to participate in sports, regardless of who they are or how they identify.
Mm-hmm.
But he concludes that, Title IX guarantees equal athletic opportunity. It cannot and does not guarantee every student a spot on the roster. And so that's kind of how the Title IX discussion wraps up.
Okay. Got it. So what about the Equal Protection Clause?
So the Equal Protection Clause, this is the one that splits 6-3. So the Title IX conclusion was 9-0. The liberals kind of wouldn't have decided. Right. So, the liberals acquiesce, but they wouldn't have decided that sex under Title IX means biological sex because BPJ didn't really contest that understanding. So they would have just accepted that, BPJ doesn't contest it. So therefore we don't need to answer that question definitively.
Mm-hmm.
But, if you accept that Title IX means biological sex when they talk about sex and you can have separate teams for the sexes, that follows that these laws are okay under Title IX.
Okay.
So for the Equal Protection Clause, though, that's 6-3. And we've already alluded to this, but the majority opinion sees this as a fairly easy case because of how it's understanding these laws and how the laws draw the line. So for the majority...
Yeah, they're just basing it on biological sex, so it's easy.
Right. Yeah. These laws discriminate based on biological sex. We know how to deal with sex discrimination. We apply intermediate scrutiny, which, means that the law has to be substantially related to an important governmental objective.
Yeah.
And according to the majority, our safety and fairness concerns in athletics are sufficient. Those are sufficiently important governmental interests. So the only real question here is, is there a tight enough fit between drawing this line based on biological sex and the stated justification of promoting safety and fairness?
Okay.
And so for the majority says, yep, there is a sufficient connection between what you're trying to do and how you're doing it. Therefore, this law is constitutional. And the real disagreement here is between the majority and the dissent is basically how tight of a fit we need between what you're doing and how you're trying to do it, because the majority is operating at the level of comparing all boys to all girls. So, if we compare all boys to all girls, there are clear physical advantages for boys versus girls.
Right.
Obviously that doesn't hold true in all cases, but because this is intermediate scrutiny, it doesn't require a perfect fit between what you're trying to do and how you're going about doing it. And so for the dissent, though, they're saying
they don't see it like that, do they?
They don't see it like that. All boys to all girls is missing the point to the dissent, because the dissent's saying this isn't an all boys, all girls thing. This is BPJ making the argument that this law, which is generally justifiable,
sure,
its purposes don't align with how it's applied to her specific subgroup. And so the subgroup is, as BPJ would describe it, are transgender girls who have no athletic advantage because of, their situation, either having never gone through male puberty or, hormone blockers, whatever it might be. So there's this subset where there are no safety concerns, there are no fairness concerns because of this factual question of whether or not there is an inherent advantage given the context.
Right.
And so, for the dissent, they would have said, like, the question here isn't whether it works for all girls and all boys. The question here is whether or not the state's justification matches the application to this particular subgroup. And the majority kind of dismisses that argument and says that, like, when looking at the validity of a justification, we look at the relation it bears to the general problem. And that, the majority actually acknowledges that a law's application to a, quote, especially large subgroup or subclass may demonstrate that there is an insufficient fit between the means and the ends. But the court says that's not an issue here because this isn't an especially large class.
Right.
And so because of that,
they don't need the protection.
Yeah. Because of that, the general justification is sufficient.
Wow.
Yeah. And so that could have some serious implications for equal protection law, because it would basically mean that, like, as long as your law is justified at the abstract, how it applies to individuals or groups within that abstract, that is less important. Less important. Right. So, like, that it kind of undermines this idea of, like, intersectionality or intersectional identities where, like, there's lots of different experiences and identities and confluence of identities within these groups that, laws might need to be attentive to. And, also going back to that, this is sex discrimination, not transgender discrimination. If that rationale sounds familiar, it's because that's the same rationale as the 11th Circuit used in the Adams case.
Oh, yeah. Out of Florida.
Of Florida, which allowed a school to define access to restrooms based on biological sex. And it was the exact same argument that, like, hey, that has the effect of discriminating against transgender folks. And the court, the 11th Circuit, said, like, no, this is just sex discrimination. And importantly, as the dissent points out here, like, that conclusion is only based on the text of the law. That has no bearing on, like, the legislative history of this, and, like, whether or not this was actually motivated by an intent to discriminate against transgender folks. Okay. This is purely a facial challenge. And, one of the laws is called the Save Women's Sports Act, which kind of begs the question, what are you trying to save it from? Which, could imply some animus, maybe.
Which is also interesting in light of how the court basically treats this group. It's like, this is not a substantial subclass,
right.
So what are you saving it from? Something that doesn't really like,
right. It is. And that's actually something that the dissent points out. Like, this group is simultaneously so pervasive that you have to protect women's sports from it, but also so small that it doesn't deserve equal protections. Right. Yeah. So it's kind of paradoxical in a way.
Yes. It is.
And so, the BPJ obviously is arguing that, these laws don't just discriminate based on sex. They also discriminate based on transgender status. And, the court rejects that. The court even goes on to say that, like, we haven't, even if we did accept that this was transgender based discrimination, we as a court haven't decided what level of scrutiny to apply to transgender-based discrimination under the Equal Protection Clause. At least 3 members of the court have said, we would apply rational basis review.
Yeah.
So that's Thomas, Alito, and Barrett. And they said that in an earlier case. Thomas is the only one who says it in this case. Thomas, oh boy. He writes a separate concurring opinion that basically makes the argument, and he's writing just for himself.
Yeah, I remember that, yeah. No, everybody else was like, all right, you can go at that one alone, buddy.
Right. And the reason for that should be apparent, because he basically says that rational basis is appropriate for transgender discrimination because of his conclusion that being transgender is essentially a medical diagnosis.
Right.
And that medical diagnoses do not deserve elevated scrutiny.
Right.
And so he writes purely for himself on that point. But the larger point that 3 justices have said that transgender-based discrimination gets rational basis, that means that there are 6 justices who haven't said either way, or, I think we know 3 justices would apply review, though I don't know if they've ever written that down.
Interesting.
So, there's the Supreme Court refuses to answer that question again, because here they basically say, whether this is rational basis or intermediate scrutiny.
Doesn't matter.
Doesn't matter. States still win.
Have the right. Yeah. Okay. So look, everybody, there's not a ton in this decision, but there's also a ton in this decision.
Right. It came out how we thought it would come out. And I think it's a very limited decision. Even though some of the breadcrumbs could lead to more significant, broader reaching conclusions later.
Exactly. But here's what I see as sort of the major takeaways here, where we're at right now. So I look at it as like, again, it's a reminder that this decision is states may do this. They may bar transgender people, girls, from playing on female sports teams. Again, doesn't go the other way. This decision says nothing about the other side of this. It's not a must. There's no requirement here. They're not saying that, states now have to implement bans on transgender athletes, transgender girls. May, not must.
Right.
But I also think there's a practical pressure as a result of this decision, right, that is a lot stronger now than it ever has been. Because you've got, I think there was an executive order or something from the Trump administration that, that basically said the OCR, the Office of Civil Rights out of the Department of Education, which probably has 3 people working in it right now or something.
A lot fewer than when Trump took office.
Yeah, but there have been directives from this administration to basically say you can more aggressively target these states that are having these more permissive policies.
Right.
I think that in light of the BPJ decision, those potential permissive policies might be at a little bit more risk if the OCR, which is the place that investigates Title IX, discrimination kinds of issues, that's where they're coming from. Listen, you get a new administration in a couple of years or whatever it is, it might, the OCR guidance might be completely different. Who knows? Right.
Until one of those cases gets to the Supreme Court and the court says that, maybe it violates Title IX to allow transgender-based, or to allow transgender individuals to compete in the team that aligns with their gender identity, or equal protection, the same thing.
Yeah. I think the other. Oh, go ahead.
I was going to say, I think those cases are working their way through the system now, based on this opinion, and how far they went to say, we are not deciding those cases. I don't know if there's going to be an appetite to take those cases up.
Yeah, I agree. So practical realities for, folks working in schools, principals, athletic directors, things like that. I think the main takeaway is don't just go at this alone. Don't improvise. Yeah. Don't make up your own rules, right? And listen, we talk about this for almost everything. It's know your state laws, know your policies, district policies. But I think the important thing for all school leaders right now, in light of BPJ, is look at your state laws, look at your state athletic association rules, and just make sure that the eligibility rules and tryout forms and, roster certifications, transfer rules, all those things that kind of govern how these sports, athletic, things play out in schools. You just look at them, make sure that they're okay, right? Make sure that everybody's sort of in alignment, and document all the time.
Always.
Right.
Yeah. And then, as part of that, also think about maybe state law doesn't align with, some of your goals, right? About participation and inclusion and affirming people's identities. Always ask okay, how can I accomplish those goals within the confines of what the Supreme Court and state law is giving me?
Sure. Exactly. Because that's I think that's another important thing to remember in this case and a lot of other cases is this does not say that you can now discriminate against certain groups of people.
Right.
And, transgender students deserve protection against harassment and intimidation and bullying and privacy and all of that stuff. They have those rights just like everybody else does. So,
right. And this decision does nothing to, I think, jeopardize some of
Correct.
those lower court decisions that have upheld those kind of protections for that population.
correct.
Yep.
Yeah. So there you have it,
Sports is
folks.
just different, I think, is the punchline of this whole thing.
Yeah, exactly. So there you have it. That's West Virginia versus BPJ, Supreme Court decision 2026. What else? Is it? Let's just go for the homework.
Yeah. Your homework is to go catch a game with Justice Kavanaugh.
Yeah, don't catch a game with me because I don't know what I'm looking at.
It could be equally as fun. Like, rate, review, Chalk and Gavel, wherever you get podcasts. Huge thank you to our research assistant, Andrea Morris, for all of her help. Go to our website, chalkandgavel.com. You can check out our merch. There's a feedback form there. Love to hear from you. Love to hear from you on social media at Chalk and Gavel. Keep the conversation going. If you have ideas for cases or other topics we should cover, just let us know. We'd love to hear from you.
Yeah, and Chalk and Gavel is supported by the generosity of the Martha McCarthy Institute at Indiana University, and we are grateful to them. So if you want to know a little bit more about law and policy and check out their June institutes every other year, go check out the McCarthy Institute at Indiana University. We thank them for their support, and we will see you all once again in 2 weeks. Have a good one, everybody.